My topic today is the topic of causation, but specifically I'm going to speak to you about a recent decision of the Queensland Court of Appeal in a matter of Greenway against the Corporation of the Synod of the Anglican Diocese of Brisbane. It's a decision which exemplifies the operation of the statutory test of causation, which now applies in every cause of action in Queensland in which there is an issue, causation, in the context of a cause of action for breach of a duty to exercise reasonable care. The position previously at common law in proof of causation sufficed if there was proved to be a material contribution of the breach of duty in question to the harm which was suffered. That changed as a consequence of two statutes bearing upon different causes of action. The first statute, enacted as long ago as 2003, but retroactive to 2nd December 2002, was the Civil Liability Act 2003. The relevant provision concerning causation was Section 11. That provision, applying to breaches of duty, prescribed various matters which, as Greenway evidences, is quite at odds with the test for causation at common law. It was followed later, indeed as late as 2010, but applying only to causes of action for personal injury in an employment scenario, that is, by injured worker against employer, by amendment to the Workers' Compensation and Rehabilitation Act 2003. The provision taken up by that Act, operative in respect of injuries which occurred on or after 1 July 2010, is, with a couple of words difference which are of no consequence, in exactly the same terms as Section 11 of the Civil Liability Act. In that regard, you can refer to decisions under either provision of the respective pieces of legislation with absolute confidence in terms of the jurisprudence predicated thereby. The essential difference is between the common law and the statutory test is very important, and very important as Greenway exemplifies. At common law, it sufficed that the breach of duty, otherwise proved, which was in question, was a material contributory cause to the harm that was suffered. A test, or a but-for test, of, in effect, factual causation was not the exclusive test or matter of proof in order to prove causation. Other considerations, namely policy considerations, would as well be taken into account in order for a court to adjudicate that causation was proved or not in the particular case. Now, all that changed, colleagues, with the enactment of the legislation of which I spoke a short time ago. But for causation was, at least primarily, a necessary matter for proof, absent which causation would not be proved. In addition to that, they needed to be proved, and it's often not a matter that is troublesome, at least in most cases, that the harm in question was within the scope of the liability. There is an alternative predicated by the statute, by each statute, and that is that the case be one which is described as an exceptional circumstance. Now, that takes up every other matter in which a party is unable to prove factual causation. That proved important, as will come now, in Greenway's case. Greenway, like so many of the master and servant cases, as we used to refer to them, involved a psychiatric injury. It was a rather sad case, Greenway's case, as these cases often are. Ms. Greenway was employed by the Synod to work as a community care worker in a residential care facility. That facility provided accommodation for troubled members of the community, particularly young members of the community, a very common matter, unfortunately, in modern mores. The particular person in question was a troubled 15-year-old boy who was living in the facility. Ms. Greenway was involved in overnight care of this troubled young man, and it was on one of these evening care circumstances in which the relevant injury was sustained. What occurred was that Ms. Greenway was manning the facility alone on this particular evening. That was the usual circumstance. She had telephonic access to an on-call supervisor, I'll call him Mr. M, who is also employed by the Synod. And in fact, she made contact with him later in the evening, as I'll come to in a moment. The troubled young man decided, for whatever reason, that he wanted to leave the facility immediately. Ms. Greenway had to cope with that. She was trained for that. The boy resisted. He resisted to the point whereby he smashed a very large window with a chair. And if that wasn't bad enough, he then proceeded to pick up a large shard of glass and proceeded to threaten Ms. Greenway with that shard. Undoubtedly, it was a terrifying incident. Undoubtedly, that primary incident was the principal cause of the post-traumatic stress disorder with which Ms. Greenway was later diagnosed. In any event, she managed the incident. She managed to talk the boy into releasing the shard of glass that he was brandishing. She managed to persuade him to return to his room. She managed to persuade him to quieten down. What she immediately did then, having done that, was to telephone Mr. M, tell him about what had occurred, and proceeded to have a conversation with him for some period of time. Now, Mr. M asked how she was. She replied that she thought she was okay. He did not, however, proceed to attend upon the facility. He did not call the police to attend the facility. He, in fact, didn't come round to the facility until the following day. It was a terrifying night for Ms. Greenway. There can be no doubt about that, and relevant findings were made to that effect. She was in an unlocked room in the facility. The troubled young man was in an unlocked room next to her. She lay awake most of the night in fear, but again in consequence of their primary incident which occurred that previous evening. She was relieved eventually the following day when Mr. M arrived.